just a minute. I'm waiting for some people to connect to audio, and we'll get started. Okay, I think we're ready. So good afternoon, everyone. Welcome to the Michigan Judicial Council's May 11th meeting. I want to welcome all of our council members, the individuals who are joining us to provide public comment, and the public watching the live stream of our meeting. The MJC holds a public hearing at least once per year, and this is a very important part of our process. It's important to the council to hear feedback from the public. We appreciate the written comments we've received, and we'll talk about those after we have some speakers talk about their feedback. And we look forward to hearing from everyone today. We will begin with Ed Pappas, who is representing the ADR section of the State Bar. Ed, if you could unmute yourself.
Thank you, Chief Justice. I appreciate the opportunity to talk with you this afternoon about the ADR section's April 25th letter to the work group chairs of the Michigan Judicial Council, and more generally about the idea of incorporating mediation into your operational plan to help achieve your strategic goals. Dale Iverson, who was one of the three people who developed the ADR section letter, has joined us this afternoon as well, primarily to answer any questions that I may not be able to answer if you have any questions. And I'm sure that you're all aware that mediators play an important role in helping parties in litigation resolve their disputes in a civil, respectful, and peaceful manner. And when parties resolve their differences on their own, their experience with the civil justice system is usually a positive one. And this goes a long way to reaching one of your goals to improve the public's experience with the civil justice system. The ADR section's letter contains a number of suggestions that can support your strategic goals. And the letter is self-explanatory, and I'm not going to go into detail on the 5 suggestions, but I'll just quickly summarize them. One is to create and maintain a statewide roster of court-approved mediators. 2 is to adhere to established court rules limiting judicial involvement in mediator selection, except when the parties request it. 3 is to implement uniform use of existing consent judgment provisions of the court rules for pre-suit settlements. 4th is to develop a data collection plan for mediation in Michigan courts to evaluate the quality and effectiveness of mediation. And the 5th is to develop consistent terminology for mediation to avoid confusion. These suggestions have not all been totally developed and need more consideration and more deliberation for implementation. The purpose of the letter was to develop a dialogue with the council with the hope that improvements in court-connected mediation are considered and where appropriate, incorporated into your operational plan. I should note that many of these suggestions, as well as the reference to an oversight committee to provide recommendations on implementation, delivery, and evaluation of ADR services in trial courts, came from a 1999 report of the Supreme Court Task Force on ADR. The Oversight Committee is not a recommendation of the ADR section at this time and was placed in the letter for historical purposes, but it may be beneficial if you haven't already done so to obtain the report and read it. The ADR section can be a valuable resource to you, and we're willing to work with the work groups to assist in the implementation of the suggestions in the letter, and also to work on any additional recommendations on the implementation, delivery, and evaluation of ADR services in the trial courts, including the idea of an oversight committee. I'm going to conclude my comments by suggesting to you that mediation should be part of the conversation as the Michigan Judicial Council moves forward with its operational plan. And if you do have any questions, I'm happy to answer what I can, and I'm sure Dale will help out.
Okay. Any questions? I think your written materials have been very, very helpful. So I don't see any questions. Thank you, Ed. We appreciate you being here.
Thank you.
Next, we have Jonathan Sachs.
Good afternoon, Chief Justice and the members of the Michigan Judicial Council, and thank you for the opportunity to comment on your work. My name is Jonathan Sachs. I'm Director of the State Appellate Defender Office. We think at SATO that we're well placed to evaluate because we practice, in addition to Michigan Supreme Court and the Michigan Court of Appeals, in circuit court statewide. My colleagues and I have practiced in circuit courts from the Upper Peninsula to Detroit, often monthly and weekly in the different courtrooms. Our attorneys handle very well the differences in reception and in court procedures in the different places, but for the people we represent and for their loved ones, often we do find that they feel like case numbers, and we are really thankful to the Michigan Judicial Council for advancing on a strategic action plan to make Michigan courts fairer, more compassionate, and more accountable. In particular, there are three goals that we wanted to comment on and really commend the court and offer for SATO to help in any way we can. First is goal one, the focus on court funding. We've been litigating for years and years the trial court funding and court costs that our clients pay. And we absolutely think that many of Michigan's most vulnerable and indigent citizens are working within a model that's not sustainable or successful, where they're helping to fund Michigan courts. So we applaud any efforts to move to a different funding structure there. Second, on goal three, racial and social equity, we see the disproportionate impact on poor people and people of color on criminal sentencing, criminal procedures, and other processes in the court system. And more data collection, more recognition of these processes, and other measures we feel like are a really good start to confronting their issues. And finally, goal four, public trust and understanding. We often meet with our clients whose biggest issue on appeal is they really just don't understand what happened to them in the criminal legal system. Often they had an objectively very, very favorable plea bargain, but no one really sort of explained to them the processes that led to that, why it's a favorable plea bargain, why there really may not be many issues on appeal, and why the sort of process might have been anything less than an assembly line in their minds and in the minds of their loved one. So we're very grateful for the opportunity for feedback there, for our clients who are actually sentenced potentially to be surveyed and to have a role there, and the increase on public trust and understanding in that process. And with that, I just wanted to conclude by saying SATO is offering and willing to help provide any assistance that we can as these and other goals move forward. Thank you to the Michigan Judicial Council for taking these steps.
Thank you, Jonathan, and we appreciate you being here today. Next, we have James Gallant. From the Marquette County Suicide Prevention Coalition.
Hello, can you hear me?
We can. Hi, James.
Okay.
Welcome.
Hello. Thank you for the opportunity here, and thank you for this endeavor that we need to reform. And I sent in a written comment a little while ago explaining my issues that we're working on in suicide prevention. And one of them is that I would hope that you could recommend to the Supreme Court to issue an order that requires comprehensive mental health services for anybody who's in any of these specialty courts and you're using courts, you're referring to mental health services. And in Marquette, we received a operational definition of comprehensive mental health services from Director Hertel from the Department of Health and Human Services, which is attached to my comment. And she's saying that to be comprehensive, it has to comply with the Michigan Mental Health Code, because now that was for our safety net providers that are the most severe cases are community mental health, but now that same standard is for mild and moderate in the new hundreds of millions of dollars that the legislature has provided for comprehensive mental health services. And that includes MCL 330.1712, individualized written plan of services, which everybody will get. They address 9 categories in a person's life: food, shelter, clothing, medical care, recreation, education, and needs for legal services. And that's what the problem here is, that 63% of youth suicides are children from fatherless homes, and they don't assess for needs for legal services to address their court-ordered parenting time, custody parenting time, where they get alienated from their families they don't live with, and that's the road to depression and the road to suicide. And it's already, issued the court-ordered standard of care. So if you would just, require the comprehensive mental health services. And number 2 is, what we're finding is that I would ask that the court would issue an order, in the judicial system in Michigan, the judicial branch of government, that we would require all the task forces, boards, and committees in this council. You need a semblance of order, and that is Robert's Rules of Order. That was created under the proceedings of Congress of the United States. This is the way we do it in America. And on page 366, line 8, Robert's Rules, is that there shall be no debate before there's a motion is properly seconded, so that everybody has the rights and they know what the question is, what they're talking about. Now, in the materials that I submitted, sorry, let me get some traffic. It was provided, this echoing in there too, sorry. They provided materials to the Michigan Independent Citizens Redistricting Commission, and Mike Brady, before the Secretary of State started the proceedings, he said only one instruction. He said, you must follow Robert's Rules of Order. So under the Constitution, our constitutional democracy has rules, laws, rules, guidelines. And Robert's Rules of Order is the fundamental principles of parliamentary procedure. And I just left today from the Marquette County. They were appointing a Register of Deeds elected official, the judge and the clerk, and they just made it up on the fly. They said, this is created by committee by statute, made it up, everything. And our elections are being certified in Marquette in direct contradiction to the Constitution. Like there's a majority, like the 2020 presidential election for Joe Biden in Marquette, they had 3 canvassers. There was 2 Republicans and 1 Democrat, yet Article 2, Section 7 of the Constitution says there shall be no majority on any canvassing board. So they're doing it in Marquette, they're doing it all across the state. And even the State Board of Canvassers they're approving these things with 3 members. There's a majority of one party in direct contradiction. So that's why I'm asking you to please establish by order of the court, in the judicial branch, Robert's Rules of Order is the fundamental principles of parliamentary procedure. So it provides equity at the meetings. You know what to expect. And people, they have all the discussion, and then they make the motion, they negotiate the motion before it's even presented for consideration. So there's no meaningful discussion after the motion at the end. They don't even ask for discussion at the end. They'll just go, okay, good, motion, second, boom, vote, because they already had the discussion. And that's deliberative democracy. That's the way they do it in the Netherlands. That's the Polder model, because they have to coalesce a consensus building. They have 25 political parties there. So that's the way they do it. And the chair of the Michigan Independent Citizen Redistricting Commission, he refused. See, they did this when they said the Pledge of Allegiance on the record. They didn't entertain a motion. The chair did not entertain a motion. She did not address that appropriately at the meeting. They didn't vote. And Secretary Benson has only been to 2 meetings. She's the secretary without a vote. She's only been to 2 meetings out of 150. So I'm not sure. They said that this Sarah Reinhart has been appointed by Secretary of State to be the secretary of the commission, Redistricting Commission, except the Constitution says nobody else, they can't even have a meeting without Secretary Benson there. So
Mr. Gallant, we can't hear you right now. Mr. Gallant? I think maybe he's having,
can you
right
hear me?
there.
Can you hear me?
Yep, we can hear you.
Yeah, sorry, I'm standing here at the library. but yeah. So that's what it's in my written statement. So that's what the 2 things I would ask for is that you ensure comprehensive mental health services for the people, and you address their court or their needs for me. A guy named Scott Hutchins from the Department of Education, he's the director of Medicaid services. He said the courts can get paid to enforce the parenting time orders through the mandated parenting time, make-up parenting time policy, that every court in the state has that. Chief Circuit Judge, it's already right now in place. And if they get a Medicaid service provider number, they can bill Medicaid for the time that it takes for the friend of the court to enforce these court orders. And then I think that's the big problem, is there's no funding. And then, I mean, they're supposed to do it anyways, but that could be a Medicaid service because it's in the mental health code that you need to address their needs for legal services. So it's not mental health, it's a part of the mental health services, because I can tell you out of experience, it's very depressing to have the system of care not protect me and my family under written orders of court. It's very clear. Every other weekend, Tuesday, I mean, it's very clear. And, you know, I documented 500 violations of that parenting time order, and they never wrote it down. It's not on the assessments. They went to court, nothing happened. From the court, they wouldn't do nothing. And, you know, it was already considered, you know, in the best interest of the children. So this is what people, they end up in, you know, the bar because they're getting alienated from their children when they should be, you know, under order of the court, be allowed to, you know, participate in their families. So yeah, that's what I'm asking. And I detailed it in the letter that I sent, and
Yes.
I'll continue to contact you.
Okay, wonderful. Thank you, Mr. Glant, for joining us today and for submitting written comments. We really appreciate your time. Thank you.
Hey, and it's James Gallant.
Gallant. Okay, Gallant.
Yes, thank you.
Next, we will have Emily Tarson review the written comments that we received.
Thank you, Chief Justice. So in addition to the 3 commenters that we had already today, we received 3 written comments. The first being from a private citizen who is requesting an amendment to Michigan Court Rule 8.119 so that courts will be required to share copies of audio and video files of public hearings with the public when requested. And the second one came from an attorney who handles immigration services. And they are looking for some standards and best practices within the relationship between the courts and FOC so that the experience from one courtroom to the next is the same for all court users. And then the third comment was from another private citizen who details their experience with the probate courts and mental health services and some of the challenges that they've run into there, and is asking for the court or the council to kind of review some of the standing orders that are taking place with mental health hearings, and making sure that those procedures are also streamlined and consistent from one jurisdiction to the next.
Okay, great. Thank you, Emily. Appreciate it. That concludes the public comment portion of our meeting. I do have 2 other items to discuss. First, in regard to official meeting procedures, I believe that you received a draft of proposed meeting procedures for the council to consider. We are asking that between now and our July meeting that you provide feedback so that a final draft can be distributed with the July meeting materials, and the council can vote to approve or not approve at the July meeting. Second, we have heard from several of the work groups that they would like to submit public comment on administrative orders or court rules. And so I guess for today, what I'd like to know is there any objection to us at least considering that? It's not really something that we've discussed before, but since it's been raised by multiple work groups and the public comment period, I believe, ends July 1st, so it will be before our next meeting. It would be something that we would need to do by email. Again, this is not approving whether or not we submit public comment. It's just something that would come up, and since we haven't spoken about it, I wanted to raise it and see if anybody has any concerns. Speak up now. Okay, I'm not hearing any concerns. So those materials will be circulated between now and I'm not sure if we have a timeline from the work groups of when they'll be ready for that. But as I said, there's a July 1st deadline for public comment. So we'll need to hear feedback from the council before that date. And that is all I have on my agenda. So thank you, everyone. We appreciate you all being here for the public hearing. And I look forward to speaking with you over email and then seeing everyone